Hi there, this is Bruno from Spainguru.es, and today we're going to talk about the Spanish Ley de Nietos or Grandchildren's Law. The so-called Grandchildren's Law regulation was approved. Thousands of descendants of Spaniards will be entitled to acquire Spanish nationality if their grandparents left Spain due to the civil war and dictatorship. This is an incredible law that was approved, and it's called the Democratic Memory Law, as it is known officially, and it seeks to help Spain make some amends for its recent past. The goals of the law are recovery, preservation, and transmission of that memory, which has been harmed by 40 years of dictatorship from Franco. The Grandchildren Law represents above all a window of opportunity for thousands of people around the world, regardless of their nationality, particularly in the American continent, Latin American countries, which have access to Spanish nationality without having to reside in Spain for a predetermined amount of time. This is very, very important, as many ways to access Spanish nationality is by residing in Spain for a previous period of time. However, not every descendant will qualify. There are only 3 scenarios or cases that are listed in the new regulation for citizenship to be granted, and let's investigate them further. Citizenship by descent, and this is the previous system, so people's options for obtaining Spanish citizenship until now by descent were rather limited. Those who had a Spanish mother or father at birth were automatically eligible, without a question. There were also other circumstances, such as adopted children under the age of 18 or children born to foreign parents in Spain if one of the parents was also born in Spanish soil, but their offspring were overlooked by the law. So now let's see what changes, let's see who can apply with the new law. There are 3 cases, as we said. Case A, or case number 1, the children and grandchildren of exiles who were born after their parents and or grandparents lost their Spanish nationality, and they have to be exiles. Case B, the children born abroad of Spanish women who lost their nationality because they married foreigners before the entry into force of the 1978 Constitution in Spain, and because they married to a foreign, maybe they lost the Spanish nationality. And the case C, probably the most common case, the adult or overage children that could not qualify to obtain the Spanish nationality by the Historical Memory Law, which is the regulated law in 2007. Okay, so for example, a Spanish grandfather in 2007 who passed his nationality to his son, and the son of his son, the grandchild, could not get it because he was 18 years old. Now he would be included, and it is possible to obtain nationality for him. Also, all those descendants that derive from this grandchild will be able to obtain nationality too with this law. As they were the children of Spanish citizens, they could previously request citizenship under arraigo familiar method. However, they may now do so in accordance with the new descendants law. Notice that the descendant may not request the Spanish nationality before his or her direct ascendant obtains Spanish nationality previously, right? So, when to apply? And this is very, very important because we have a limitation in time here of just a couple of years. So we only have 2 years to apply using this law, which is valid until October 20th, 2024. There is the possibility to extend the period for 1 more year if there is agreement in the Spanish Council of Ministers. However, there are high chances that there will be no extensions because there are political issues here in play, and there may not be agreement. So consider 2 years window to apply using this law. How and where to apply? The application declaration of option should be submitted 1. by interested parties using the official forms provided in Annexes 1, 2, 3, and 4. And if you click the link in the description of this video, you will go to the article and you will find all the links here to all the forms. And number 2, before the head of the General Consulate or Consular Office of the Civil Registry of the applicant's address. Notice that if the applicant was born in the territory corresponding to the demarcation of another civil registry office, in which case the application and documentation submitted will be sent to the civil registry office corresponding to the birth location. Alright, so far so good. Now let's see the application process. Number one, making an application using the official forms, as we said. This form can be obtained online and in person, and as I said, here you can find the links. Submission of the application must be in person at the civil registry office, and please notice, in person, okay? So you have to do it at the civil registry office of the applicant's address, together with a photocopy of the application. This application, when submitted, will be stamped at the civil registry office and returned to the applicant as proof that the application was submitted on time. Remember the window of the 2 years. And number three, the interested party may file an appeal in case of denial of the nationality option due to non-compliance with the requirements of Law 2022, which is the law that we're talking right now about. Alright, so now we go with the documentations for the different cases, okay? We have case A, as we said, case B, and case C. Case A, and for all the cases, the applicant's ID, the applicant's birth certificate. This is common for all the cases. And then, case A, we have number three, the birth certificate of the applicant's father, mother, grandfather, grandmother who were originally Spanish. 4. If the application is made as the grandchild of a grandparent who was originally Spanish, the applicant must also provide a literal birth certificate of the applicant's father or mother corresponding to Spanish grandparent. Number 5, the application that proves the exiled status of the father, mother, and grandparent. And this is a big question. How do you prove that he or she was exiled? So basically, like, you have to gather all the information that you can to accredit it. And here we have some examples. For example, for this last point, an immigration documentation that may be present in the local consulate may be potentially used to prove it. Okay, number 1, documentation that proves having been a beneficiary of pensions granted by the Spanish administration to exiles. Number 2, documentation from the UN International Refugee Office that assisted Spanish refugees and their families. Number 3, certifications or reports issued by political parties, trade unions, or any other entities that are recognized by the Spanish authorities or the exiled host state authorities, which are related to the exile. So, something that proves it, okay? The status of the exile will be presumed, and this is very, very important. The status of the exile will be presumed, okay, or proved, to all Spaniards who left Spain between July 18th, 1936 and December 31st, 1955. However, the proof of exile status must be provided when the exit from Spain was between January 1st, 1956 and December 28th, 1978. The departure from Spanish territory must also be proved. Okay, you need to prove that the person left Spain, and foreign certificates must be legalized and apostilled. If the documents are not in Spanish, they must be translated by sworn translator. Okay, this is, of course, for all the cases that needs to happen. And documentation for case B, applicant's ID, birth certificate, and number 3, birth certificate of the applicant's Spanish mother. Remember, this is the case in which a woman, Spanish woman, married with a foreigner elsewhere abroad and had to renounce or lost the Spanish nationality. So you need to provide birth certificate from her. Number 4, marriage certificate of the mother with a foreign national dated before 29th December 1978. And 5th, for marriages formalized between August 5th, 1954 and December 28th, 1978, documentation must also be provided proving the acquisition by the mother of the husband's nationality and document accrediting the foreign legislation of the acquisition of nationality by marriage in force on the date on which it took place. And again, you need to translate and legalize and apostille all this documentation if needed. Okay, the translation, of course, is in Spanish. You don't need to translate it. And documentations for case C, okay, is, of course, applicant's ID and birth certificate. Number 3, Spanish birth certificate of the father or mother of the applicants of legal age when their parents have been recognized as having Spanish nationality by origin by virtue of the right of option when the application is presented in a civil registry other than the one in which the birth of father or mother is registered. Okay, so Please consider that this article is no legal advice, or this video, and it's based on internet research only. Of course, if you need to receive immigration expert advice, please go to spainguru.es, and here you will find all the links to the immigration experts. You can also have health insurances, relocation services, tax advisors, etc., etc., etc. You can also join our community. Our biggest group has more than 60,000 members, and it's on Facebook. Spain Immigration and Residency Questions. You can ask all the questions related to this topic and immigration to Spain topics. And we also have Spanish Non-Lucrative Visa Facebook group. We have Digital Nomad Visa. And of course, I invite you to join our newsletter that we send every single Monday morning with the top discussions on our communities. All right, well, this is Bruno from Spainguru.es. If you like the video, please subscribe to the channel, like the video, help us out with the algorithm in YouTube. And that's all. Thank you so much, and have a wonderful day. Goodbye.